All right, good afternoon. Welcome to the Athens-Clarke County Board of Elections and Voter Registration Special Called Meeting. The date is April 1st, time is 4:40 p.m. We're at 2555 Lexington Road, Athens, Georgia. First item on the agenda is to adopt the agenda. Chair will entertain a motion. Okay,
Second.
motion, Ms. Still, second, Mr. Kadir. All those in favor say aye.
Aye.
Agenda is adopted. We've been advised that there will be no public comment today.
Oh, no, there can be. I don't know what your normal procedure is.
Okay, well. Yeah, so let's, do public comment. Is there any members of the public? You can write your name after you speak, it's fine.
Let me say now.
You can stand there if you'd like,
Sure.
or you can come up here, it's up to you, but let me get the timer going here.
I'm probably gonna need 3 minutes.
That's fine, but go ahead.
I'm Tony Meadow. I'm the current Clarke County Tax Commissioner, and I'm here about the challenge for JP. I just wanted to say that I ran a candidacy and a campaign, and I was a county employee, and I was a county employee in the Tax Commissioner's office. Nobody ever challenged me. No, I didn't get anything from the attorney's office, from the manager's office, from the mayor and commission saying that I was unable to do that. So I just want to say, I think it seems rather odd if I was actually in the office that someone didn't challenge and question the fact that I could run for office while I'm still a county employee. So I just wanted to make that comment. So.
Thank you. Anyone else? Now we're moving on to new business, and the first item of new business is the hearing regarding candidate challenge for tax commissioner candidate JP LeMay. Before we begin, none of us are lawyers in this board, and we're doing our best to make sure this is a fair and correct hearing and everyone gets ample opportunity to state what they need to say. So just want to make that clear that I freely admit, may look like we're amateur hour here, but we're under good hands over here. And other board members, you want to say anything before? Sure. Okay, could you just kind of walk us through what we're going to do here and how we're going to do it?
Absolutely. So I'll try to be as brief as possible. What I will start by saying is that, as I think some people know, we don't have these types of challenges frequently. And so there are no rules of procedure for this specific type of hearing that we are aware of or that we could find. And there are certainly none that are prescribed by the statute. I will say just for clarity, when we're talking about the statute today, we're referring to OCGA section 21-2-6, which outlines the ability for an elector to challenge the candidacy of a given candidate for office. In order to do our best, what we're going to rely on are some very basic procedural rules that exist in virtually every kind of hearing in some form or fashion that you might engage in any kind of court. Now, obviously, this is not a court, but we're going to try to honor those because the statute does specifically require us to create a record, because there is an opportunity to appeal the decision of the Board of Election. We want to make sure that we create that record and do everything as properly as we can. So the first rule is that there will not be any comment from anyone other than the challenger and the candidate during the hearing, except for any witnesses that they may choose to call. In other words, this is not an open session where other people other people are parties to this. In the way that maybe a hearings board matter, you may have neighbors who have a right to come speak because it affects them. The only speakers allowed today will be the challenger and the candidate and any witnesses that they call. Secondly, we do recognize that in a traditional court of law, the way it would work, and again, clearly this is not a court of law, the challenger and the candidate would both be given the opportunity to make an opening statement. They would then be given the opportunity to call witnesses or to testify themselves, in which case any witnesses, including themselves, could be cross-examined by the other party. And then at the end, the challenger, so the person who's initiating this would have the authority or the opportunity to make a closing argument first, in which case the candidate would have the opportunity to rebut, and then the challenger gets the final word. I certainly recognize that the board has the ability to be flexible. I don't know if we need to be that formal. It is certainly possible that the challenger and candidate both came here today intending to basically make a statement on their own behalf, similar to an oral argument, and that's the only statement they intend to make. So I would encourage us to have a quick conversation about how the parties would like to proceed. But if we want to proceed in a particularly formal way, that is the outline that I will use, particularly if there are witnesses to be called. Next, both parties certainly have the right to introduce exhibits into the record, because again, we are required by statute to create a record. If either party has any documents that they want the Board of Elections to consider, we would just ask you to identify those at some point during your presentation that you want to introduce exhibits. We will identify any documents admitted to the Board of Elections as either challenger exhibit X or candidate exhibit X. We will handwrite that on each of the records, and we will need to keep those records. So once it's introduced, it will become property of the government and a public record, and will be kept with the record of this hearing, along with the audio and video recordings and any other documents that are going to be admitted. I will say, and I don't know if this has been made, it looks like it has been made available to the candidate and the challenger, but the Board of Elections staff have prepared what's been marked as exhibits 1, 2, 3. There are multiple sub exhibits of 3, so it's 3.1, 0.2, 3, and then exhibit 4. These, I presume, will be admitted into the record by staff for the Board of Elections consideration, unless the board has an objection to that, as records that were in staff's possession and that are relevant to this inquiry. Let's see. We do not intend to impose a time limit today, as long as it's reasonable. I think the Board of Elections certainly has the discretion to decide at some point if it has become unreasonable to limit continued debate or discussion on a topic. And then, see, once the evidence is closed, the board will then enter into deliberations, which they will do so publicly. We have a written form for which they will make a decision, and the board will sign at the end of this meeting. For efficiency's sake, I will be typing that document and we will print it off. We ask that the candidate and the challenger remain after the conclusion of the hearing and after the decision has been made, so that we can quickly provide that to you, because your appellate rights begin today, and we'd like to make sure that you have that. So if you'd like to pursue any appellate rights, that you can. Final thing is that the jurisdiction for, and maybe that's not the right word, the scope of today's hearing is solely based on the notice of pre-election challenge. So the only grounds for challenge are those that are contained within that document. Does the board have any questions?
Can you clarify that last statement you made, that the only grounds are what's in the document?
And it's this first page.
That's right.
Okay, that's one.
So OCGA 21-2-6 allows for an elector to challenge a candidate by filing a complaint or a challenge within 2 weeks of the date of closing of qualifying. This was filed on the last day, so it is timely file. But there's no opportunity to amend or to resubmit new challenge paperwork after that deadline. So what we have before us are the grounds, and I would assert that there's no ability to add new grounds at today's hearing. So the topics, the relevant discussion today will be what is contained in this challenge.
Okay. All right. Parties? Formal, informal, what are we thinking here?
Informal is fine for me.
Okay, we're pretty casual group here, so would you two mind sitting here if that's fine?
Just a quick question, are either of you calling me witnesses?
Yeah.
Okay.
Or you can go one at a time if that's more comfortable, that's certainly fine. So the board's in agreement with informal, we're good with that? Okay. So you're recognized to make an opening statement if you'd like, or and just present your whole case if you'd like.
y'all have the form that I sent in for the challenge. I think it pretty much black and white states my case. I was notified by a past ACC politician, and no longer is a politician, about this code that Clark County has. And they told me they didn't think JP was allowed to run due to its employment with ACC due to the code. So we looked it up, and it's in kind of black and white, stating what it states. There's a code similar with the state of Georgia. It doesn't apply to the county, but the state of Georgia code states the same thing about state employees running for office. And then, it states that the local codes may have a similar code in place, which Clark County does. I brought the matter up to Mr. Williams, the city manager. And basically on our phone conversation, he basically said nobody has ever pushed the code like I am, so they've really not done nothing about it, but he thinks that they do need to restructure the code to bring it more up to date. But as of right now, the code's pretty black and white in what it says. So that was my case for bringing this up on y'all.
So then we'll go to the other opening statement and then come back.
It seems that this would be the full statement, is that correct?
Yep.
You don't intend to make any further statements, other than a revoke?
You may begin.
Good afternoon. My name is JP LeMay. I'm a candidate for tax commissioner in the May 21st primary election. I'm speaking against Mr. Spratlin's challenge to my candidacy. Mr. Spratlin has cited section 1912F of the Athens-Clarke County Municipal Code in his challenge. He contends my status as a current employee of the unified government of Athens-Clarke County disqualifies me from being a candidate. His argument is flawed on 2 counts. First, only Georgia state law sets the qualification criteria for candidates seeking the office of tax commissioner. OCGA 485210 lists those qualifications and requires candidates to file an affidavit affirming that they meet the qualifications stated in this code section. I do in fact meet all 6 of the stated requirements and have filed a sworn affidavit affirming the same when I qualified to run for this office. Second, Chapter 19 of the Municipal Code of Athens-Clarke County relates to the personnel system of the unified government. Section 191B establishes the personnel policies for conduct of the employees covered under the system. The remainder of Chapter 19 acts as a de facto employee handbook. The qualification criteria for any elected office is not mentioned anywhere in Chapter 19. Interpretation and enforcement of the provisions of the personnel system falls under the purview of the manager's office and the departments that report to him. Mr. Spratlin brought the same challenge to County Manager Blaine Williams before filing this challenge with the board. In response to Mr. Spratlin, Manager Williams informed Mr. Spratlin that section 1912F was reviewed by both the attorney's office and Human Resources. Human Resources guidance is that an employee cannot campaign while at work or on the clock, which I will not do during this campaign or any other. This guidance is consistent with well-established precedent. Several Athens-Clarke County employees in the recent past, including Tax Commissioner Tony Meadow, Sheriff John K. Williams, and Clerk of Superior State Court Elisa Zarate, have qualified to run for public office while employed by the unified government and were not asked to resign or have their candidacy challenged. Mr. Spratlin also contended that should I be allowed to remain as a candidate and not win the election, that I might retaliate against the taxpayers of Athens-Clarke County through my position with the Leisure Services Department. This could not be further from the truth. As a longtime employee and a taxpaying resident of Athens-Clarke County, the idea of retaliation because I don't care for an election result is preposterous to me. I have every confidence in the elections office staff to conduct a fair and accurate election and will accept the results of the May 21st vote, whatever that might be. I ask that you reject Mr. Spratlin's challenge to my candidacy, leave my name on the ballot for the May 21st primary election, and allow the voters of Athens-Clarke County to choose the candidate they feel is best for the office of tax commissioner. Thank you.
And no witnesses.
Mr. Sprout, or Robo.
The only rebuttal would be that, HR said that's the way it interpreted it. There's no campaigning while on the clock, but yeah, I think it's because nobody really pushed the code. So you can, it's like saying the speed limit's 50, but I'm gonna interpret to go 70. The code's in black and white. So I think they're just interpreting it that way to keep from a lawsuit occurring, in my opinion, because nobody's pushed the subject in the past.
Right. Do we deliberate now?
So at this point, having gone through both statements, I think the evidence is closed. No exhibits were admitted. And so at this point, you have the ability to now deliberate based on the documents before you and the testimony or argument that you put.
Quick question. Are we allowed to ask the candidates questions?
That is an excellent question.
We've done that in the past with voter eligibility, not necessarily candidates.
What I would say is that there are no rules telling you one way or the other. So I think if you all decide that you would like to ask questions, that you can, and it is certainly routine and less formal, and even some fairly formal judicial settings for judges to ask questions. So I think it would be appropriate if you all felt the need to do so.
Okay, the floor is open. Anyone else would like to make a comment or a question, or go ahead?
Yeah, I can start on that, on the 2 points, which I have deliberated with myself mostly over the weekend. It says to be active in political affairs and campaigns. And that is the Clark County statutes. Do I understand that correctly? Is there anything, and this is a question for our attorney, is there anything that y'all may have come across in the state statute that clearly says that any county employee is not allowed to run for anything?
No, there is nothing, Mr.
Yeah, to me, that was one key that just kept coming out, that if the state had meant for someone not to be able to run for a position while they are employed, it would have been in one of the state statutes. That's my position. I do have one question for Mr. Stratton, if that's okay to add. I mean, he's made a good point, or from here, that should Mr. LeMay lose, he could retaliate. Generally, when I think of the word retaliate, it's usually against a person, that one get a position and power can do that. How would one be able to retaliate against the system or against a district or against?
I mean, I don't know Mr. LeMay personally, but it's just in general, you're working for the county, the electors that are voting you in. I will say, you asked about the state, does the state have anything in place? I read several things over the past few weeks leading up to this. And like, it does say that although the state doesn't have that in place, that the counties are allowed to have their code in place. So the state kind of left it up to the counties is the way I interpret it.
Pretty standard with
Yeah.
many things.
So your point about retaliation is,
It's a possibility, but I don't know Mr. LeMay personally. so
well,
I
yeah, I
can't say.
understand that. I'm just saying theoretically, how does one retaliate against a system? Because we have checks and balances against a person, I can see. But I just wanted to hear your side.
Sure.
I believe if it is a county regulation, and we live in the county, and this is a county election, that we should abide by county rules and regulations. As we saw the last time we were here, people said that if this is the law, we should abide by the law. And I'm picking up on that thread today because they all voted to abide by the law. I don't think that it has to be a county or a United States rule or regulation. When it's a county regulation, we are county, we're not really employees, but we are the face of the county, the Board of Elections. And I would not want to go against a county regulation.
Can I speak to that at some point?
Yes. Let's have the board members, because I imagine you're gonna say the same thing I was gonna say, but. And unless Ms. Tilly, you would like Ms. Science to go.
Anyone that wants to speak?
I'm happy to wait.
Okay, but did you have anything?
Yes.
Yeah, go ahead.
Thanks to the attorney's office advice on this, I feel reasonably confident that I understand the relevant facts and what the law says, but I want to be certain because of the significance of this. I have three questions about this. Does the law require that we as a board, given the certain situation, remove the challenge candidate from the ballot? Is it specifically requiring us to do that?
This is an interesting question. So what the statute says is that you have to determine once a challenge is made is whether the person's qualified to proceed as a candidate for that office. If you determine that they are not, then the person is removed from the ballot. But, and that would be a requirement in the event that you determine that the candidate is not qualified. Does that answer your question?
It does. So then the qualifications that are, if you use the term qualifications in law, does the state law, Mr. Stratton referred to, or one of the gentlemen referred to the qualifications spelled out for this position, eligibility requirements. Those are OCGA requirements, I imagine?
They are, yes.
Would you mind, I know that's, I'm sorry, it's in.
I've got it. So it's.
It is.
Sorry,
It's actually the affidavit for the qualifier.
Oh, that makes sense. It would
It's
list it there.
exhibit 3.3.
Thank you.
Perfect. But it refers to statute OCGA 48-5-210. But if we can certainly look in front of it, that's what makes it easy. Yep, this is exactly right. So, and typically there are some sort of like random, slightly esoteric requirements that could come up. For instance, if someone was holding illegal monies is one of them that was listed. But these are the primary ones, and certainly none of these have been challenged in today's hearing. So first, that the person must be a United States citizen, that they have to be a resident of the county in which they seek office for at least 2 years prior to the election, that they have to be a registered voter, that they have to be age 25, that they have to have a high school diploma or its recognized equivalent, and that they cannot have been convicted by a felony offense. So those are the primary qualifications, and those are set by state law.
Thank you. And so then, Brent, given the affidavit that was filled out by both candidates, but in this case, relevant, the challenge candidate, notarized, and with the work that was done by staff, that should we proceed as though the candidate's qualified based on these 6 criteria? Right.
I think that's an excellent question. So there's been no challenge to this affidavit or any of the contents of it. So I think the correct legal answer is you would proceed as if the person is qualified unless the grounds raised in the challenge are related to a separate qualification and therefore could disqualify the person.
Okay, thank you. I'm almost finished. Thank you. So with these 6 qualifications that are set out by state law, much like our board bylaws, wherever we conflict with local ordinance or state law, federal law, they prevail. In the sense they control, I guess is what I've heard used. In the same way, a local ordinance where it conflicts with state law would then control.
That's right. It's the principle of preemption, and that's
Okay, thank you.
exactly right. So the idea is that where the state has specifically passed a law that outlines a certain thing, unless it also says local counties can set, for instance, their own qualifications for this particular race, which it has not done, then we are preempted from passing our own ordinances that would seek to overrule the state law. Does that make sense?
It does. Almost finished. So then, given that these are the criteria set out by state law, and the state law has these as the candidate's eligible, then unless I'm not seeing where an opening is left by state law, that local ordinance could rule a candidate ineligible for a seventh criteria or any others. And I'm not seeing where county ordinance, local law, in this case, is clear on this rendering a candidate ineligible. I'm wanting, I hear what Ms. Till is saying, but I'm trying to see where either of those things are there. I'm seeing it, but I could be wrong.
That's correct. The attorney's office does not see that either.
Okay.
There's no state law that gives the county the ability to pass local legislation regarding the eligibility of any candidate for a state race, or a local race for that matter. And secondly, the county attorney's position would be that this code section said it doesn't speak to eligibility. It speaks to employment and personnel matters.
And then just to wrap up then, it sounds to me like not only, so we are not required by state law in this situation to remove the candidate from the ballot. I'm not hearing that we even have the flexibility to consider whether to. I'm hearing more that it sounds like we are required to leave the candidate on the ballot because they are eligible based on the 6 criteria set out in state law, is what I'm hearing, unless I'm hearing something wrong.
I see your question. The answer is that the Board of Elections has to make the decision. All you are required to do today by law is determine whether the candidate is qualified or not qualified to proceed based on the candidacy information you have and the challenge that you've received. The decision is yours, and if either the candidate or the challenger disagrees with that decision, then they can appeal it.
I agree that this body's purpose is to determine the eligibility of a candidate based on these criteria, and it's clear that Mr. Lemay has met these criteria in front of us. One thing I was thinking about was if a candidate worked for private industry and they had a similar HR policy or whatever, it's not our place to tell, for example, Amazon what they need to do with their employees. It's a little bit, I think, more gray here since we're all connected to Athens-Clarke. That's how I'm looking at it. I did, so there was, in the document you sent us, there was the email from the manager. So I wanted to bring that up if that's appropriate. I didn't see it in.
It is a public record. Are you saying that you would like for that to be included in the record today?
I actually would. I'll ask the board members if they are okay with that. And do we need to give a copy of it to them?
I think they both have seen it, but if they would like copies, we can certainly make them. We would certainly want to add one to the record.
Would you, either of you like a copy?
I have one.
Okay. Yeah, Ms. Susby, may I bring you that?
You could label that as Exhibit 5.
And would that be board exhibit then, or what?
If you'd like, you could make it Board Exhibit 1. That would be fine. Just as long as we're clear.
Okay, I'm gonna make a board exhibit 1. Everybody good with that? Okay. This email that everyone has seen, I think, kind of sums it up for me in that we've done our duty and determined that the candidates on the ballot are eligible. They've met the criteria that's required by law, and I close that page. So that's where we've done our duty. Now, the person who is responsible for personnel in the county, the manager ultimately, has decided that they will take no action related to the enforcement of this. They've consulted with HR and the attorney's office and determined that it's an antiquated policy. And I believe, didn't it reference unification, like it hasn't been revised since like the 90s or something?
Oh, yes, that it hasn't. That's correct.
Right. So the fact that they're looking at it, seeing there's a problem, making adjustments and changes, so it's more relevant to where we are today, to me. That's, those are the two points I have to make. We can if we would, if we like. The question was, what we'd like to do, closing statement from either candidates, is that appropriate or?
So I am not, sitting in any judicial function here. I did announce earlier that I
Right.
believe that the evidence was closed because I understood that both parties had, certainly, again, there are no rules here. So if you decide you'd like to hear further comment, you could choose to do so.
Okay,
Or I'd like to see if they would have a final comment.
okay, okay, yeah. Do we need to take a vote?
No, you have the discretion of the board to decide how you want to proceed.
Okay. So I guess you would go first and then it would be last. So if you have a closing statement or some type of thing you wish to leave us with.
I have nothing further.
Thank you.
I was reading the election guidelines and stuff and, the OCGA 45-10-70 is where state employees can't run for office without resigning, whatever. It says non-state employees are not subject to this code or the statute. But it does say individual counties and other political structures may have ordinance or regulations similar to OCGA 45-10-70, which create a mechanism for a challenge related to incompatibility of office. And that's what Clark County has in place, which would, even though the state doesn't have that code, the county does.
Thank you. I would say that the comment that Mr. Shirley made earlier, that state code would preempt any county ordinance. I do know,
Can we get that?
yeah,
Can you tell us where to find that preeminence of state law?
Sure.
I just wanted to add one little anecdote. This is not our full-time job, and in my full-time job, I'm a state employee. And I know that I cannot run for any office it must be municipal level and below for state employees, so.
To your question, Ms. Tell, preemption is a legal doctrine, so there isn't a statute per se on preemption. But it is a fundamental legal principle that basically any legal entity that is a higher sort of up the food chain, for lack of a better word, has the ability to control an issue over someone that's lower on the food chain where they have that jurisdiction. And so I realize that's kind of a silly way to describe that. I could talk about it more. I think the best area to look for would be in our home rule statute in OCGA, and that's in Title 36. And I should know the sections, but I can't tell you right off the top of the head. But basically what it stands for is the provision that where state law has specifically carved out things that are the duties or powers of a municipality versus a county, or sometimes there's a few for unified governments. And for unified governments, we generally take both. That those are clearly our powers and our authorities. If it doesn't speak to that, in other words, it's totally silent, we generally have the ability to move forward with our own legislation. But when it speaks to it, you can have both explicit preemption and implied preemption. And I think we're here in a situation where the preemption is quite clear that the state law has set forth the requirements for candidacy, and we don't have any ability to make those changes. So even though this ordinance exists, and even though we could, potentially Manager Williams could take an action regarding Mr. LeMay's employment, that is a separate matter to whether it relates to his eligibility under state law. I don't know if that helps you at all. I'm happy to send more information later about
Could you do
preemption.
that for me?
Sure.
Right, any board members have any other comments? Questions before we proceed with deliberation, I guess? No, sounds like you were reading something. Okay. So do we need to enter into a motion and a second and then deliberate?
That is the typical process for Robert's Rules and Orders, so I would follow that since we don't have any other guidelines.
Okay. The chair will entertain a motion to allow Mr. LeMay to remain on the ballot.
I so move.
Okay, second, Mr. Kadir. All right, now go ahead.
You made the motion?
Oh, right.
Yeah.
You're making the second. I'm sorry. Let's keep that in here. Okay, yeah, now the floor is open for discussion. So, any further discussion, deliberation?
Yeah. I mean, it's difficult for me to even consider anything that might preempt the state law, otherwise then we'd be getting into challenges. And I hear Mr. Stratton's point about retaliation, that's, it's theoretically is possible, but I'm just hoping we have a system where if, Mr. May did lose and system would be able to stop him to be able to retaliate because it's not going against any individual. So that's why I make a motion.
Okay.
A motion.
Okay. Any other comment? Mr. Shirley, Ms. Hill? Okay. All right, we will call for a vote. No,
Before you vote, the court, or sorry, the state law does require that you articulate a decision or sorry, a reason for the decision. Or at least we would recommend that you do that in this order. So when you vote, it would be helpful if there's some sort of reason that we can for the decision.
okay, so should we go back and revise the motion? Is that where that would live?
I think that that would probably be the cleanest under Robert's Rule of Order, and I apologize for not saying it earlier. I think that would be clear sort of expressing the board's intent.
Well, in that case, I would draw the motion.
Okay, you can
So we
amend
can-
it, you can amend
So
it.
we can amend it or,
If you wish to amend it, it just needs to be re-seconded.
what does it say, John? Okay.
I would, it has said, I began typing what I was going to propose an amendment. It just said that,
Without,
it just read to allow Mr. Lemay to remain on the ballot.
due to the. Yeah, that would work.
So I would suggest amending friendly amendment, adding due to failure to prove ineligibility.
Yeah, because what we're talking about eligibility comes from the state.
Might I add a reference to, and correct me if this code section is wrong. Eligibility falls under 48-5-210. Is that correct, or is it in 21?
That's correct.
Okay,
Okay. Yes, I did. Thank you, Chair.
let's read it again to make sure that it's,
So the amendment is okay? You like the amendment? So motion by Mr. Kadir to allow Mr. Lemay to remain on the ballot due to failure to prove ineligibility per OCGA 48-5-210. If that wording is acceptable.
I think so. Does that meet state requirement?
I think that's fine.
Okay.
And I've written the exact same. The DOE voted, and again, I don't know how you're going to vote, but I'm just writing the same case as how you voted. DOE voted to allow Mr. Lemay to remain on the ballot due to failure of challenger to prove ineligibility for OCGA section 48-1. So I think I added failure of challenger, but.
Okay. Mr. Kadir, are you okay with the word
Yeah.
failure of?
Yeah.
Okay. Do we have a second?
Second, but now, wait, we're changing the to of?
Due to failure of challenger to prove.
Thank you. That's okay.
Yeah. Reference that code.
I'll second that.
Okay. Last call for discussion. Now that we've had a proper second. Okay. All those in favor of the motion on the floor, raise your hand or say aye.
Aye.
Aye. All those opposed, raise your hand or say no.
No.
Okay, the motion does pass. With 3 voting yes and 1 voting no. Okay, attorney, do we need to Do we move on to the next
Yes.
agenda item, or do we need to wrap the paperwork up and then move on?
So I would ask that the challenging candidate remain if they don't mind. I have just finished typing that. I'm going to email it to Ms. McGlone. We'll print it off and then we should have just a minute or two for you all to sign. And then we can make copies of the signed version for them, or so they
Should
can.
we recess the meeting for 10 minutes or just stay on? Is it-
I don't think the next matter will take a great deal of time, and I will need to fill out a few things on this, so I'm happy for you to continue, but whatever your preference is.
We can just. Continue.
We can always take a recess very briefly, if you'd like, once the paperwork is ready for you to sign.
Oh, yeah. Go ahead.
I just saved it, I'm sending it now. 1 second.
We. This board exhibit one go to Charlotte, to you guys, or?
I think it would make sense for Charlotte to have it. You'll need to maintain the record, which will include the audio and the recording for this meeting.
I don't, we need to send to the manager's office or HR.
Okay. Yes, yeah. It'll take a bit to get that.
Thank you. Yeah.
So now.
Just in case.
Staple box.
I didn't, yeah, it was just in case.
It's the first, of course. That's right. Voting against.
Right underneath it, signatures.
Whatever you prefer. We left lines, only for signature, but if you'd like to,
Oh, sorry, you want me to-
okay, then if you want to put your printed name, that's perfect. Let's see, right?
Yeah, mine's the same. I usually put in parentheses my name.
Okay. You have a few less lines, but I think you're like very useless. This, here on the left.
On the left. Joe, this is,
It doesn't matter, you use whatever one you want.
It's do you want?
I told you to pens. because I'm scared of the windows.
Oh, and I apologize. I'm asking you all the time. It's supposed to show you the originals. So, here, I'll press this down. You all can look. So, I'll start with you. So this just shows the challenge prerequisites, which staff had already determined, the challenge reason that the candidate is qualified, the reason that we stated on record. And then all of the different exhibits that were admitted by staff, the board exhibit 1, and then there were no exhibits from challenge or candidate in the final pages, the second page of RBC. So we'll look at that further and pass along.
I think we've seen
Okay.
Here's an extra copy.
If you'd like it to be.
So the first 2 pages, if you want to look at
It's two copies.
just references the challenge prerequisites, the reasons of the challenge, about the candidate qualified, the reason we stated, and then the next page basically just lists all the different exhibits. And then that's for the go under and everything. Okay, any questions? All right, I can have both of you sign this for me. You want to step up, just. This is not saying you agree with it, this is just acknowledging service. And what we'll do is after you've signed, so that way everyone has a full copy. So if you can sign there where it says challenger, please. And Mr. Lemon, if you can sign. Have you signed technically for the service line? Well, I don't know this. Actually, no, we don't need, never mind. Okay, so Ms. McClellan, if you just make copies.
Okay.
How many copies? We'll need 2 for them, and then does anybody else need a copy? Okay. If I can have 1 copy, so 3 copies and then the original. Thank you so much. Okay.
What do you just give them that? Oh, wow. Did you see the city of Winterville's Aprilville?
No,
Fool's joke?
the only thing I remember is, this is my brother and my sister-in-law's wedding anniversary.
Oh, goodness.
39 years.
The city of Winterville posted this morning, they received a $20,000 grant to cut down all the trees. or something.
Oh, somebody needs to.
While we're waiting, I'd like to wish Mr. Spratlin and Mr. Lemay a wonderful spirited campaign.
That's all I remember about
Copies. Can we proceed with?
Absolutely.
Oh, okay. All right. Next item on the agenda is the discussion regarding application for recall election. And, that was put on by staff, so recognize the director unless a board member has a preemptive comment.
Good afternoon. So there are 3 steps to recall application. And that is found in 21-4, in the back of your code books. For some reason this time, I think I'm very proud of the state, how they did this. It's in our Title 21, software book. And then, so they put the recall act in there. So there's 3 steps. One is the application process, and that's in 21-4-5. And then the recall petition, which is 21-4-8. And then the recall election itself, 21-4-13. So
13-4-8.
yes, 21-4-13. So staff issued a petition application to Mr. James Lee, who wishes to recall the seats of District Attorney Deborah Gonzalez, Sheriff John Q. Williams, and Mayor Kelly Gertz. And
that was issued on March 13th. So there's a 15-day period for us receiving the application back from Mr. Lee. The date is on March 28th. We received the applications back early morning on March 28th, and staff began verifying signatures. And so we have verified that there are a sufficient number of signatures on each application to move forward to step 2. And we have provided those recall petitions right now for your review. And so within 4 days after the application is submitted for verification, the board, you are to review the sufficiency of grounds for recall. And then upon your review, we will contact Mr. Lee so that he can begin the second portion of the recall. And, of course, he would be required to have 30% of the active registered voters from the last election of which office was elected. And I have those numbers. Those will be provided when we provide the petition. But it's your duty as the superintendent to determine if there are grounds for us to issue the petition.
Okay. So when you say 30%, let's say that person received 1,000 votes, 300 people, or is it 30% of?
It's 30% of the registered active voters at the time of that election took place.
Oh, so you have to go back and look, and if it was said 62,000, then
Yes.
30% of 62.
Yes. Yes. And so, just for the record, the sheriff was last elected in 2020. So we would go with the total active registered voters in the November 3rd, 2020 general election. And then the DA was elected, December 1st, 2020 in a special runoff, general runoff. And then the mayor was last elected in 2022 at the May 24th, 2022 general. So we would look at those active numbers. A lot more than what you have there, because the application requires 100 signatures. So though we were able to verify the number of signatures that were required for the application.
Okay. Yes, go ahead. Just-
The Director Sosby, this is the petition for the application for the recall.
Yes.
This then, by what state law lays out, because they've each, in each case, 10% have been reached, they are then eligible, sorry, we are supposed to determine whether they are eligible then to then have a petition they can then begin circulating. This does not lead into a recall election. I misunderstood that. I thought that just getting 100 people to sign up for it meant that there's an election, and that was terrifying.
Application first.
Okay.
And then we'll have the recall petition. Now, once that's done and there are sufficient numbers for that, then there's a recall election.
I see.
And then if the recall election results into a vacancy, then there's a special election to fill that particular.
And then-
That falls on, there's only like 5 times when you would have a,
Nope, these will be held not in conjunction.
I remember that. That's a standalone
Yeah.
special exception to the rules.
separate, but yeah, what is a separate, but
And the reason why it's like that, because there's certain days in between which the ones, it's like 30 to 45 days. So the board, you can make a call to hold a special election, and you have to make that call within a certain time frame. And it does not meet up with the, so that, I'm thinking it would be separate from,
At any rate, we're not there yet.
But,
We're
right.
not.
yes,
It's okay.
but I'm sure that would be, into before that.
Gotcha. And then,
Hopefully, we can be held in conjunction, because that does look like we'll be having 7 elections this year, possibly.
right.
So,
So what we're here today for is just our signaling, agreeing that staff has vetted these and that they've met the minimum requirement for the next step, which is not the election. I'm just curious, if I'm a candidate if I'm an elected official who's subject to this, when do I have a chance to speak? When I was looking over the law, is there?
there is, grounds for challenge, not really challenging, but to for an officer to respond to? Well, let's see.
Charlotte, I can help if you want me to. Please. Yeah. So board's role is to determine the legal sufficiency of the applications of course. The affected candidates, their clock has also started. It's a separate consideration. So they have a very short window as well to, you're looking at the legal sufficiency of, are there enough valid signatures, very administrative. They have the ability to appeal to the Superior Court about the actual grounds that are stated for their recall.
Okay.
Okay, so that's a separate matter outside of, it would be in Superior Court should they choose to avail themselves of that. It's a very short window. They have 4 days.
But we're not.
But you're not part of it.
That's all.
Yeah.
Are we at that point yet for them? I know we're not part of that, but is that the next step? That's when the actual petition's been
So
fully filled out or?
that's a really good question because there is some inconsistency in my mind in the statute
Yeah. about
about whether or not that those are overlapping periods or whether they are, they run consecutive to one another.
Right.
There's case law that suggests that their clock begins at the point that the applications have been verified, okay? Statute reads as if they're stacked up on top of each other. I will say, just kind of, for my purposes, I didn't spend too much energy thinking, but because that's on the candidate and their counsel to sort of figure out, do you know what I mean?
Okay.
In terms of what that interpretation of that kind of that would be.
Okay.
I was, our concern is that you all have exactly 5 days from the point at which those were returned to you.
So we are just here to verify the sufficiency of the signatures on this.
That's exactly right.
Thank you. Thank you, Mr. Chair.
Yeah, and
Could someone clarify the code section that lists out the criteria we're judging this on? Unless we have it, I'm pretty sure you've sent it to us already, but,
I think Charlotte just referenced it.
21-4.
oh, it's,
Yeah,
okay, okay.
21-4.
I don't have my.
I got you.
yeah, that's what I thought was.
Steve,
It's 21-4-5.
Yeah.
what do you say?
It's for Claire. Did you?
Yes, there shall be at least 100 or 10%.
Would you just read that out loud so Ms. Toll can hear it?
Sure. I hear the number of official sponsors necessary to file an application for a recall petition must be equal in number to at least 100 electors or equal in number to at least 10% of the number of electors who were registered to vote at the last preceding election for any of the candidates offering for the office held by the public official sought to be recalled, whichever is smaller.
So for your purposes, one.
That's what these are, the fractions on these papers here refer to that number, all of which are.
Oh, I see. Got it.
Yes, and I want to also add that the petition that will be given would just be for mayor and sheriff. Because the district attorney qualifies with the Secretary of State's office, that petition has to be filed with the Secretary of State's office rather than us. Yeah.
Is the state election board supposed to make the determination of the DA then?
Not sure.
Who would
I think-
decide that?
So,
Even on the grounds of,
no, you would make the decision based on the application because the application was applied through us. And then we sent it to council and the Secretary of State's office. And then they will carry out with issuing the petition for that office.
So the reason we only have 3 packets here is it because we are not included, we're not a step in determining the sufficiency of a DA's race? Or where's right here? Wait,
You are based on you are based on the number of signatures that we
I
verify.
beg your pardon, I'm sorry. There were 4.
Actually,
That's 33.
three, there were never
so you
four.
have the
You have the
DA.
application.
There was a commissioner listed initially, and that candidate or this petitioner doesn't live in that district.
That's what I forgot. Thank you.
What that was. Okay. So, the floor is open for a motion. I would invite the motion maker to include these numbers in their motion. If that makes sense, and I'm happy to just do it.
I would love to make a motion, but I want to be clear on what verb is appropriate to use.
We're gonna put it together and then move it.
I move that we
These
Accept.
signatures are valid registered voters.
to accept the sufficiency of the recall petition application based on the number of voters having been
Yeah,
met. That's
that's a little clunky, but
verify.
verified. We verify that the petitioner has met the minimum number of signatures required under OCGA 21-4-5 or whatever it is. And then semicolon, district attorney 159, sheriff 118, mayor 126. Is that a six?
Mm-hmm.
7? 6.
I think it's a six.
1, 2, 6.
Like, what's that?
Well, there's like a 7 and
126.
It's 126.
we need,
Oh, we found a duplicate on that. Yeah.
we need the vote review panel to review it.
I know, right? I do remember that now. Yeah, we should have just marked through that.
So I guess, sorry, clean up my motion. I move that we verify the sufficiency of the applications for recall petitions submitted for district attorney, mayor, and sheriff. I'll have to amend that, but that's,
I would suggest, or make an amendment after we have a second, to include the actual numbers
okay.
of signatures received, like in parentheses after, where you list the 3 offices.
Okay,
And should we mention Athens-Clarke County or not?
Ready? We can begin.
I currently have a motion to verify the sufficiency of the applications for recall petitions submitted for district attorney, mayor, and sheriff. And I was beginning to add, having received those signatures for each respectively.
Motion, you might have a look over your shoulder. Motion by Mr. Shirley to verify the, I would just say, hold on. To verify,
If I may,
yes,
if there's just some question about the district attorneys, did y'all ever hear back? Did y'all hear back from them finally about what, so they do want us to do the signature verification at the county level? Okay. And then we'll just turn it over at that. Okay, yeah, there was some question about at what point they wanted us to turn it over from the county to them, but
sufficient number of signatures
yeah.
after the
At
word.
least I'm gonna send you stuff.
Sufficient change to verify the
Are you print now?
number of signatures
Well, let me get that.
required
In the next few minutes. We've had to do that for like nomination petitions where the state will send them from county to county and, yeah, we verify.
Gotcha.
And then we send it to the next county and.
Yeah, and it's just such a uncommon thing, right? At least for us, we weren't sure about the process, but it's like we got it nailed down, thank you.
Yeah.
Included number.
Okay,
Let's thank the and do it strongly against the numbers. It's good to have in minutes.
yep. 1-4-5. We are in,
Now, when I say numbers, not the, it'll be these numbers, these 3, not the code sections.
but not a citation of the code after that? For OCGA.
Oh, right, sorry.
But that, okay.
Yeah.
Person, petitioner, the applicant. James. James. Just like that, I thought it had a hyphen or something. L-E-E. L-E. Okay, easy enough. Easy enough. Thank you.
Okay, Mr. Chair, I'm ready to read the motion again.
Go ahead.
I move that we verify the receipt of a sufficient number of signatures for the applications for recall petitions submitted for district attorney, mayor, and sheriff, having received the signatures of 118, 127, 159 eligible electors respectively for OCGA 21-4-5C.
Looks for me.
We don't need to add, here, so Clark County, Georgia. It's a given. Yeah, you're right.
Okay, so that's your motion. Does anyone wish to second that motion?
I so move.
I just would want, I'm sorry, when it's time for discussion.
Floor is over for discussion.
I just want to be sure that's sufficient wording as far as the attorney's office is concerned.
Yeah.
Motion by Mr. Kadir to verify the receipt of a sufficient number of signatures for the applications for recall petition submitted for district attorney, mayor, and sheriff. Having received the signatures of 118, 127, and 159 eligible electors respectively for OCGA 21-4-5C.
There are, yes, I think that would be sufficient. I will say there are other things that we were gonna check off that staff has verified otherwise, when Charlotte told you about the dates, so that it was returned within 15 days and things like that. So perhaps something more general, more general that other requirements have been met as well.
Can we just put other requirements?
Yeah, as verified by staff or however you would normally.
Are you okay with that?
Yeah. I'd say, verified by staff, verified by superintendent.
And then they need to put, it's the application too, it's the recall application, because you have the application, then you're gonna have the actual recall petition.
Right.
That they have to go on.
Read it again, just for sure.
So the signatures, I want to be sure I understand, the signatures you're saying are only one of a couple of different steps that need to be verified,
Certainly it's the bulk of it.
but not the only. So then I'm just trying to think of the best way to verify the receipt of a sufficient number of signatures for the application for recall petition submitted for the offices, having received the signatures of the number of signatures respectively per code section. Where should we work in, do you think, would you suggest, incorporate the language about and other requirements have been met also?
Maybe at the beginning and then go into read the first couple.
To verify the receipt of a sufficient number of signatures, verify the sufficiency of the application.
There you go.
Okay.
Yes.
Okay, just one.
All right, it's clunky, isn't it?
And a point of order, I think, Adam, you were making the motion and then Hankin seconded. Initially when we started.
That had been the case, but
Yeah.
Okay.
Are we ready to base?
How would you, Ms. Davis, sorry, how would you suggest that we articulate the other steps that have been, or just simply refer to steps because of it? How to make it sound?
Let me show you. I think if you could certainly just reference the code section we were speaking to. Maybe you could say that. How about that? Would that be a more general?
Right. Rather than
Yeah,
spelling out.
and they're all within the code section.
Okay.
If that's amenable to you. That can happen right up there. She's my baby. So it's only one.
Okay, how about this?
All right.
Motion by Mr. Shirley to verify the sufficiency of the applications for recall petitions submitted for DA, mayor, and sheriff, based on the requirements stipulated in OCGA 21-4-3 and 21-4-5, including the receipt of signatures of 118, 127, and 159 eligible electors respectively.
It's
Did that address what you
126.
Ma'am?
It's 126.
Thank you. I'm okay with that, if you're okay with that,
Okay,
if you're okay with that, as a motion,
you okay with that?
if that's okay with the attorney's office also,
All right, let's take a vote.
Mr. Sure.
thank you.
All of those in favor of the motion on the floor, say aye.
Aye.
Aye. Any opposed, raise your hand or say no. Your motion passes. All right. Final item on the agenda are announcements.
Mr. Chair, may I ask, usually just to, once again, reiterate what the next process is that includes the petition, just briefly an overview.
One more.
What the next step will be after this.
Not us for a while.
Right,
It has to.
So it's about 45 days from the day that the petition is issued. 45 days because it exceeds the number of 5,000. If it was 5,000, it'd be 30 days, but it's 45 days that the petition can be circulated. So you'll meet, we kind of have a tentative.
and I think you said 10% of the number of registered voters. So
30%.
30%.
30%. Yeah, I kind of got a, like a tentative timeline, if it, just based on what I read, that this May 17th will be 45 days from tomorrow.
Okay. Well, how does that process work? I mean, the physical process, they would have to go out and get those signatures.
Since, well,
That's not our job to worry about.
I need to go take care of my family, and that's not business. I think if you want to have a conversation with the director after, we can do that. But, if everyone's okay, I'd like to move on.
Okay.
Announcements, Tuesday, April 9th is our regular meeting. We'll be at West Doherty Street, 120. Monday, April 22nd is the last day to register, and the first day absentee ballots may be mailed out for the May election. Monday, April 29th is when advanced voting will begin. Friday, May 10th is the last day to request an absentee ballot for the May 21st election. Tuesday, May 21st is the last day to vote in the May election, and it's election day. Maybe we should report that next time. There's a motion on the floor to adjourn.
I so move.
Okay, do we have a second?
I'll second.
Okay, all those in favor say aye.
Aye.
Aye, meeting is adjourned.
It's printing on, you can just sign really quickly. Sorry.
At least trying to go to classes and do a show. Yeah.
I'll get you signed real quick.
I gotta do,
And then I'll get the other.
gotta do.
Then I'll fill it in.
Yes, so 45 days from state to us, and I think we have like 30 days or
Yeah.
15 days to verify that.
You had like 30. Yeah, you got a while because it's like one second.
Thousands.
I mean, if you've really got a rush and you want to come by the office to sign it like tomorrow.
No, I can
then just-
wait a few more.
Oh, but I think it's just turning on.
Oh, and.
When was the last time a recall was done in Athens-Clarke?
Got my.
There was one done, but, there was a recall.
You brought the sign real quick. Yeah, that's how it is.
Yeah.
So it's adjourned.
Have a crowd, yeah, but this is crazy.
That's the only one that I'm aware of, but that was quite a while.
Yep.
Yeah.